Okay, Dr. Ambrose, I will pass the floor to you, okay?
Yeah, thank you, Dr.
Okay.
Ting.
The recording is on, but I won't be around. I will just shut the speaker down, and I'll mute myself. So the floor is all yours, okay?
Yeah, thank you very much, Doctor.
Thank you.
Yeah, good morning, everybody. Yeah, welcome to.
Dr. Ambrose.
Yeah, some of you I've known you during the previous class. Yeah, risk management. Yeah, people like Ibrahim, Nicholas, Ling. Ling, how are you, Ling?
Yeah,
Your sound looks terrible, Ling.
maybe that internet was not poor.
Okay. How is China now today?
It's very cool.
All right. Yeah, welcome back, yeah, Ling. And to the rest, yeah, welcome to this class. I'm Dr. Ambrose. I will be supervising Sasa and Brenda for the project paper RP1, yeah. You have shared with Dr. Ting this morning, yeah, on the overall governance regarding the whole structure of parliamentary, how the law is being passed in Malaysia. Yeah. So now our task is direct to contract act. Yeah. Malaysian Contract Act. Yeah. Probably Ling can share with us some of the contract act in China later. Yeah. Now, very important for all of you, because you are going to have group assignment with me. Yeah. I'm not sure how many altogether in the class. Yeah. How many students? Yeah. Anybody know? Yeah. Never mind, because we will divide the group according to the total number of the student later. Yeah. We will divide. Let's say if many of you, maybe we can go by 4 or 5% in the group. Yeah. Before we have 2 or 3% in a group. Yeah. Depend on the number later. Yeah. Now, the course learning outcome, very important for you to know. And I want you to relate your group assignment to which course learning outcome. Yeah. For example, course learning outcome 1. Yeah. You demonstrate the application of engineering knowledge in contractual agreement. So what we are saying today is contractual environment. Yeah. And perform your task. Yeah. Within the context of the Malaysian legal system. That is what we will be covering. Yeah. Towards finishing my class. More on the Malaysian legal system, the ordinance, the relevant ordinance, and the relevant act. Yeah. Now, number 2, CLAO 2, formulate solution that take into account the legislative, the contractual issues, while addressing the economy, the technical, managerial issues. You see, it is not enough just to learn the theory part, yeah, of the law or of the engineering knowledge, but you must use this knowledge to come out with a solution, yeah, within the context of the law, the legislative, yeah, within the context of the contract act, yeah, but at the same time you address what are the economic aspect of it, the technical aspect, and if you are the boss, you are the managers, yeah, in your organization, in your company, what are the issue that you need to address. Yeah. So that is CLO2. Now, CLO3, you organize a team. Yeah. A team maybe like what I said just now can be 2, 3, 4, 5, depend on the number of students. Yeah, in your class. Yeah, to carry out research. Actually, your project paper actually is a minor research or minor thesis. Yeah, it's not the whole thesis. It's just partial thesis. Yeah, to carry out research and to study to come out with solution. Yeah, but the solution must adhere to legal practice. Legal practice in an engineering environment. You must always remember that you are studying in an engineering environment. Yeah. So when you do your group assignment letter, make sure you come out with your objective, with the answer to the question that we will provide later, yeah, on the assignment, and relate them to this 3 CLO, CLO1, CL2, CLO3. Yeah. Any question on this first before I move? Nicholas.
Can you share the slide, Doctor?
Later I will share the slide. Okay. But because I need to look at the name first. Yeah. No problem. Later I will share the slide. Yeah.
Okay.
Nicholas, what do you think? What is your comment?
Yeah, Doctor.
Yeah. Do you understand what I'm trying to say just now?
Yeah.
Yeah. Very good. Yeah. Can you explain to me? Number one, on the CLO1. Yeah. See, I said CLO1, the application of engineering knowledge, yeah, in contractual environment, yeah, and performing our tasks within the Malaysian legal system. Yeah, that is CLO1, right? Okay. Natasha. Ika Natasha, are you there?
Yes, I'm here, Doctor.
Oh, all right. Do you understand? Yeah.
Yeah.
Okay. Can you explain to me the CLO2?
Formulate solution that take into account of the legislative and contractual issues while addressing the I think technical and managerial issues.
Yeah, plus the economy issue. Very good.
Economic,
Very
yeah.
good.
Yeah.
Very good. Sasha, about CLO3.
Yeah.
CLO3.
The objectives for in the engineering environment.
Correct. Yeah. You do the research, yeah, to study in order to provide solution. Yeah. But within the legal practice in the engineering environment. Yeah. Thank you, Sasha. Right. Now, let us see the Malaysian Contract Act. Yeah. Don't worry about the notes. I have the notes. Later on, I share the notes to all of you. Yeah. Now, the Contract Act 136. Yeah. Contract Act 1950. Yeah. We just go briefly first. Okay. Part 1 of the Contract Act 1950. Yeah. Part 1, normally in any act, it talk about preliminary. Yeah. It consists the short title, the interpretation of the act. Okay. Part 2, it talk about the communication, acceptance, and revocation of proposal. Yeah. How do you communicate? How do you accept? How do you revoke a contract proposal. That is what actually it means. Yeah. So how many sections are in part 2? There are 7 sections. Yeah. Communication, acceptance, and revocation, 1 section. Section 4, communication when complete. Section 5, revocation of proposal and acceptance. Section 6, how do you make a revocation? Yeah. Section 7, acceptance must be absolute. Yeah. Section 8, acceptance by performing condition or reserving consideration. Yeah. And section 9, promises expressed and implied. That is part 2. Now, part 3, yeah. Part 3, it consists of the contract. What is contract? What is voidable contract? What is a void agreement? Yeah. I will explain to you in detail later. Yeah. I have the notes. This is about the act first. Yeah. Don't worry about the detail. We will discuss later on. Yeah. Now, what are agreement to a contract? Yeah. Who are competent to contract? Yeah. Which party? Yeah. What is the meaning of sound mind for purpose of contracting? Yeah. What is consent? What is free consent? Coercion, undue influence, fraud, misrepresentation, yeah, voidability of agreement without free consent, power to set aside contract induced by undue influence, yeah, agreement void where both parties are under mistake as to the matter of fact, yeah, the effect of a mistake as to law, yeah, contract caused by mistake of one party as to matter of fact, yeah, and what consideration and object are lawful and what are not lawful, yeah. So these are under the meaning of contract, voidable contract, and void agreement. Yeah, that is part 3. Now, part 4. Yeah, void agreement. Agreement void if consideration and object unlawful. Yeah, if there is no consideration, the object are unlawful, that is void. The agreement is void. Yeah. So agreement without consideration, void. Yeah. If there is no consideration in the agreement, it is void. Unless it is put in writing and registered. Or a promise to compensate for something done. Or is a promise to pay a debt paid by limitation law. Yeah. Or agreement in restraint of marriage is void. Yeah. Agreement in restraint of trade is void. Yeah. But they have 3 exceptions. Exception 1, saving of agreement not to carry on business of which goodwill is sold. Yeah. Exception 2, agreement between partners prior to dissolution. Exception 2. Exception 3, yeah, during continuation of partnership. These are the 3 exceptions. Yeah. And section 29, agreement in restraint of legal proceeding. These are void. Saving of contract, yeah, to refer to arbitration dispute, yeah, and saving of contract to refer question that have already arisen, yeah. And section 30, agreement void for uncertainty, yeah. Section 31, agreement by way of vague void. That is 31.2, 31.1, yeah. agreement by way of waiver void, that is 31.1, 31.2, exception in favor of certain prices for horse racing. Okay. Now, under Part 4 of the Contract Act, yeah, that is contingent contract. What is the meaning of contingent contract? Enforcement. When the event contract is contingent to be deemed impossible, yeah. When the contract become void, which are contingent on happening of specified event within a fixed time, yeah, or when a contract may be enforced, which are contingent on specified event not happening within the fixed time, yeah, or Section 37, agreement contingent on impossible event, right? Now these are the detail. I just briefly go through, yeah, so that we can focus on the discussion, yeah. Part 5, yeah, the performance of the contract, yeah, there are obligation of the party, effect of refusal to accept offer, effect of refusal by party to perform promise, yeah, and person by whom promise is to be performed. Section 42, effect of accepting performance from third person. Section 43, devolution of joint liabilities. Then you have Section 44 on joint promissories, yeah. Section 45, the effect of release of when joint promissor. Section 46 on the devolution of joint rights. Section 47, 48, 49, 50, 51. Right. So under the performance of reciprocal promises, there are 5 sections, 6, 7, 8, 9. And under appropriation of payment, yeah, under payment part, you have Section 60 to Section 65. Then you have the contract. Under the contract, you have Section 66, 67, 68. Then under Part 6, yeah, certain relation resembling those created by contract. Yeah, under Part 6, you have Section 69, 70, 71, 72, 73. And Section 7, Part 7, yeah, the consequences of breaching of contract. Yeah, you have Section 74, 75, 76 under Part 7. Under Part 8, yeah, indemnity and guarantee, you have Section 77 to Section 83, yeah, 84 until 100, yeah, and Section 9, yeah, you talk about bailment. What are bailment? What are bailer? What are billy? Yeah. So Section 101 to 1 to 4. Yeah. And then bailment of pledges. Yeah. From Section 1 to 5 to Section 132. Yeah. And then suit by bailiff or bailer against wrongdoer. Section 133 to Section 134. Yeah. And Part 10, yeah, agency, yeah. How do you appoint and authorize of agent, yeah? Section 135 until 142, sub-agent, Section 143 to Section 48, ratification, Section 149 until Section 153, revocation of authority, Section 154 until Section 163, agent duty to principal, the duty of the agent to the principal, yeah. Section 164 until Section 174, yeah. The principal duty to agent, Section 175 until 178. The effect of agency on contract with third person, this is under section 179 to 183. The presumption of contract to contrary, section 184 until section 191. So that is the overall flow of the Malaysian contract, yeah, which I will share with all of you later, yeah. Now, let us go to the real discussion, yeah. Now, for your group project group work, yeah, which is under CLO3, yeah, remember to connect it to your CLO3, the marks will be 20%, yeah. Individual assignment 40%, and then final exam 40%. Okay. Now, what is Contract Act 1950 in Malaysia? Yeah. So this Malaysian Contract Act 1950 or Act 136, it set out the legislative framework governing contract in Malaysia. Now, Afiq, every contract in Malaysia need to adhere to Malaysian Contract Act 1950. Yeah. If any of the contract did not follow the Malaysian Contract Act in Malaysia, do you think the contract is valid or not? Afiga Hasri. Brenda, what do you think, Brenda? Hello, Brenda.
No.
No, very good. Why do you say no, Brenda?
Because the objects are unlawful.
Yes. Any contract that did not adhere to the contract act will be void. Yeah. So under section 2 of the Interpretation Act, yeah, the following words expression are used unless contrary to the intention, yeah, unless it means against the intention, yeah. When one person signifies to another person, yeah, his willingness to do or to abstain from doing anything, yeah, with a view to obtaining the assent of the other to the act or to abstain, yeah, he is said to make a proposal. So that is a proposal, yeah. When a person tell or signifies to another person, he is willing to do or abstain from doing anything, either doing or not doing, yeah, with a view to obtain the agreement, the action, yeah, the agreement to act or not to act. Abstain means not to act, yeah. So that is what we call proposal. Lisa, can you give me one example of a proposal? Melissa, can you help Lisa?
Example of
Can you-
proposal with
Yeah, just an example of a proposal.
business proposal.
Yeah, business proposal. Yeah. Now, for example, I want to buy a Toyota Rush. Yeah. So I tell the salesman, look, sir, I got 10,000 deposit here. I want to buy a Toyota Rush. Yeah. So that is a proposal from me to the salesman. I want to buy a Toyota. Yeah. So that is an example of a proposal. Very good. Yeah, thank you. Now, what is a promise? Yeah, when the person to whom the proposal is made, he signifies his action. That means his agreement. Yeah. So the proposal is said to be accepted. A proposal, when accepted, becomes a promise. Yeah. A proposal, when accepted, become a promise. Mr. Lee Juntek, yeah. Can you give me an example of a promise?
Sorry, doctor, I'm not quite sure about that.
Oh, you're not sure, yeah? How about
Deposit.
yeah, who's that? How about no Nickman? How are you, sir? No Nickman?
Hello, doctor. Yeah. A signing of contract is considered as a promise.
Yes. A promise is when you agree, when you sign the contract, that is a promise. Lee, when you tell the girl you want to marry her, that is a promise. So, do you understand now? Yeah. You tell your girlfriend, I want to marry you. That is a promise. Yeah. And you have to marry her, Lee. Yeah. Okay. Thank you. Now, next we move. Yeah. Yeah, Brenda. The person making the proposal is called the promisor. Yeah. If you make the proposal, you are called the promisor. And the person accepting that proposal is called a promisee. Yeah. Now, Siti, I'm I'm buying a car, rush, yeah, a car rush, yeah. So, who is the promisor here?
Dr. Ambrose.
Yeah, because I propose to buy the car. I'm the promisor. Who is the promisee here? Sasa. Toyota, the agent, yeah? Very good. Thank you. Now, when at the desire of the promisor, yeah, the person who make the proposal, the promisor, yeah, the promisee, the person accepting the proposal is the promisee, yeah, or any other person has done or abstain from doing, or does or abstain from doing, or promises to do or abstain from doing something. Such act or abstinence or promise is called consideration for a promise. So the question is, what is a consideration for a promise? Yeah. If at the desire of the promisor, yeah, the person making the proposal, yeah, the promisee, the person accepting, yeah, he want to do or he want to not do. That means abstain from doing, yeah, or he promised to do or he don't want to do, yeah. Such an act is called a consideration for the promise, yeah, consideration for the promise. Now, Adriana, can you give one example of a consideration? How about yeah, sorry.
In terms of which one, doctor?
When you do certain act, right? Yeah, when you do certain act, yeah, what is that act that constitute or become a consideration? Can you give one example? About Ibrahim, we want to have Adriana, Ibrahim. Jessica.
Consideration to sorry ya, tiba-tiba tak boleh bercakap. To consider the for both party, for example, if before signing a contract, you need to consider both parties whether they agree or not on the conditions of the contract.
Yes. The other both party consider the term and condition. Yeah. So that is the consideration. Yeah. For example, you need to pay a deposit to buy a new car, 10,000. So that is the consideration. Yeah. The deposit I pay to the agent, to the Toyota. So that is the consideration. Yeah. Thank you, Jessica. Yeah. So every promise or every set of promises forming that consideration for each other, that is an agreement. Yeah. If I promise or I make a set of promises, yeah, forming the consideration for each other, that become an agreement. That means me, the buyer, and he, the seller, we promise to each other. So that become an agreement between me, the buyer, and the Toyota, the agent, as the seller. Okay, that is an agreement. Thomas Chong, are you there, Thomas?
Yes, doctor. Yeah.
Very good. Now, can you give me an example of an agreement?
An agreement is is it like a contract or the acceptance of for example, acceptance of the terms and conditions?
Correct. Yeah. For example, the two buyer, the seller of the house and the buyer of the house, they already agree. Okay, I buy this house, I pay for this house 500,000. Yeah. So once they agree on the term, on the condition, then they sign the contract. Yeah. So that becomes the agreement between the two parties. Very good, Thomas. Now, promises which form the consideration. Yeah. If you promise something and that become part of the consideration, yeah, for each other, yeah, that become what we call reciprocal promises. Yeah, it means the promises which become part of the consideration or part of the consideration for each other. Yeah, that means the payment I make for the car, or the deposit for the house, or the deposit for the car, that become what we call reciprocal promises. That means we both agree. Reciprocal means the buyer and the seller agree. So they agree to the term and condition as promised. Yeah. An agreement is not enforceable by law if it is what we call void. Yeah. So remember, yeah, an agreement that cannot be enforced by any law is said to be void. Yeah. Bibi Amira, are you there?
Yes.
Yeah. Bibi, can you give me an example of a void agreement? An agreement that the law cannot enforce.
Selling of drugs.
Selling of drugs. Why? Why do you think? Yeah. Why do you think selling of drugs cannot be enforced?
Because according to Malaysian law, drugs is illegal.
Yeah, probably
Some drugs
maybe
lah, some type of drugs.
yeah.
Not the pharmaceutical drugs lah. Illegal selling of drugs.
Right. Yeah, you correct it very rightly, yeah, PB. It means illegal drug. Illegal drug means drug not approved by the government. Yeah, not approved by the government. Yeah, for example, heroin. Yeah, these are illegal drug. Heroin. What else? Huh?
Endangered animals.
Endangered animals. Yeah, those protected animals. Yeah, these are a thing that you cannot do because of certain limitation as provided by the law. Yeah. So whatever you do, whatever agreement you have in anything that contradict the law, it is considered as void. It means you cannot enforce it. Yeah. Now, so an agreement that is enforceable by law, that is called a contract. An agreement that can be enforced by law, that is a contract. Yeah. Dalia Jarai, are you there? Hey, Ika, okay, Ika, can you explain to me?
Oh, so, doctor, I have question.
Yeah, okay.
How about a verbal agreement? Is it considered a void?
Oral agreement.
Yeah.
Yes, very good question. Yeah. How about an oral agreement? Is it a valid contract? Lisa, what do you think? Lisa, before I give my comment.
Verbal agreement.
Yeah.
I'm not sure.
Not sure, yeah. How about Mahmudin?
Maybe can be a contract if the verbal conversation is recorded.
Right. If let's say the verbal agreement subsequently become written agreement, yeah. Normally, verbal agreement, it has to be enforced by written agreement. Like what Mahmudin said, there must be some kind of evidence. Yeah. For example, maybe a recording of the conversation. Yeah. Or the oral agreement put in writing. That become valid contract. Ika. Yeah. So there must be some evidence to prove that there is some oral agreement. Yeah. Is that answering your question, Ika? Okay.
Yes, sir. Yes, sir.
Yeah, good. Now, an agreement which is enforceable by law at the option of one or more of the parties. That means one or more party, yeah, but not at the option of the other party, is a voidable contract. Yeah. This agreement, one person can enforce, but not at the option of the other party. So that is voidable contract. Yeah. Later on, we will see the example and the meaning behind. Yeah. The next one, yeah. A contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. Yeah. So it means a contract which cannot be enforced by law anymore. Yeah, it becomes void. So when it becomes void, you cannot enforce. That is what it means. Yeah. So now the question is, what actually constitute a contract? What actually constitute a contract? Okay, listen, yeah. A contract is legally binding promise. Ika, legally binding promise, written or oral. It can be written or oral. Yeah, by one party to fulfill an obligation. One party to fulfill an obligation to another party in return for consideration. Now, yeah, remember, a contract is a legally binding promise, whether written or oral, yeah, by one party to fulfill an obligation. There is an obligation they must fulfill. Yeah, for example, paying a deposit. That is an obligation. In return for consideration, in return for the car, in return for the house. Yeah, so that is a legally binding promise. Yeah, okay, which is either written or oral. Yeah, so what legally constitute a contract? Yeah, by definition, yeah, an agreement between private parties creating mutual obligation is enforceable by law. Yeah, so the basic element required by any agreement to be legally enforced contract, yeah, are number one, mutually assent. That means both party agree, mutually agree. Yeah, expressed by a valid offer. Yeah, there is a valid offer, a valid acceptance. A valid offer, a valid acceptance. Adequate consideration. Yeah, by paying of deposit. That is adequate consideration. Whether the party is incapacity or not. Whether it is legal or not. Yeah, now. What are the key elements of a contract? Yeah, so a basic binding contract must comprise 4 key elements. There must be offer, there must be acceptance, there must be consideration, and the intent to create legal relation. Yeah, sometimes people say there are 5 essential elements of contract, but some people say 4. Yeah, so there must be an offer, yeah, which is a promise and a demand of something. Yeah, there must be an acceptance, yeah, which is the agreement to the term of the offer presented. Yeah, consideration, which is what actually presented in exchange for something in the contract. Yeah, I pay the deposit in exchange for the car. I pay the deposit for the house. Yeah, in exchange for the house. So that become a contract. Yeah, capacity. Now, what is the meaning of capacity? Melissa, are you there, Melissa?
Yes, doctor.
Yeah. What do you understand by capacity in terms of contract agreement?
Means party has the legal ability to enter into a contract.
Yes, that is right. The legal ability. Now, if a person is a minor, Sasa, can he or she sign a contract?
Legally for the contract to be bound is when one person is wise enough to understand the contract.
Yeah, in other words, the person must be of legal age, no more a minor. Yeah, that means he is already matured to sign a contract. He understands the contract. Yeah, so that is the meaning of capacity. Yeah, can a person of unsound mind sign a contract? Thomas Chong.
No, doctor.
Why no?
Because he don't have the capacity.
Yes, because a person of unsound mind, yeah, he don't have the mental capacity to think about the contract. Yeah, very good. So, a binding contract is any agreement that is legally enforced. Yeah, it must be legally enforced. That means if you sign a binding contract and you don't fulfill your end of the bargain, the other party can bring you to court. Yeah. So the legality is that the contract has to obey all federal, state, and local laws. Yeah. You cannot make a contract for something illegal. Yeah. Now, human trafficking, Brenda. Are you there, Brenda?
Yes.
Yeah. Human trafficking. Is that an illegal contract or legal?
Illegal.
That is illegal. Thank you, Brenda. Yeah. What are stipulation? Yeah. A condition or requirement that is specified or demanded as part of an agreement. Yeah, that is stipulation. Yeah, a condition or requirement that is specified or demanded as part of an agreement. Yeah, for example, they donated their collection of print with the stipulation that they never be publicly exhibit. Yeah, so if they donated their collection, yeah, of the print, that means the printing of certain book or whatever, yeah, with the stipulation, yeah, with the stated agreement that they will never publicly exhibit that print. So that is the meaning of stipulation, yeah. So if the term of the contract are clear and leave no doubt upon the intention of the contracting parties, that literally meaning the stipulation shall control or the contract is valid. Yeah. So if a stipulation of any contract can have several meaning, the meaning which will be most adequate to render the stipulation effective shall be at the top. Yeah. In other words, they could have so many meaning to the term. Yeah. But the most nearer meaning to the term, the most adequate meaning to the term, that will be adopted. Yeah, that will be used. Yeah, for example, the definition of a stipulation, yeah, is a condition or the term of the agreement. Yeah, so that definition, that condition, that term become part and parcel of the agreement. Yeah. Now, for example, of the example of stipulation, yeah, it means you stipulate something means you want to make that become part of the agreement, yeah. So when you make a contract or a deal, you can stipulate. That means you can state the condition that you must have in the agreement. For example, if you want to run a fencing company or you want to offer a sale, you can stipulate that to get the sale price, yeah, the fence must be ordered by a certain date. So it means in order for you to carry out the sale, yeah, the fence must be ordered or must be bought by certain date, yeah. So that is the term and condition that you want in the agreement, yeah. So the term and condition refer to the contractual rights and the obligation of the party to any contract, yeah, yeah. For example, you sign the scholarship agreement. Lee Juntek, do you receive any scholarship for your study?
No, doctor. I'm under PTPTN loan.
Okay, that is considered another agreement, PTPTN loan agreement, right? Did you sign any agreement for the PTPTN loan?
Yes.
Yes. So your rights, your obligation is stated clearly in the PTPTN loan agreement. Yeah. What are the example of your rights in the PTPTN loan? Mr. Lee, can you share with us? Give one example.
To receive the money on every semester?
Yeah, very good. To receive certain amount of money every semester. Now, what is your obligation, your duty to fulfill in the contract, Mr. Lee? Because the PTPN will require you to do certain thing every semester. What is that?
With a pass-in credit, like at least two pointer and above.
Yeah, that means Mr. Lee must achieve your semester result, minimum 2.0 and above, right?
Yes.
Yes. So these are the example of your obligation, of your rights in the contract agreement. Yeah. So the term and condition refer to the broader concept of the guideline the party must follow when they do agreement. So your business can create them for any formalized business agreement. Yeah. You can create this term and condition. Yeah. So normally you will call them, okay, what are the term and condition I want to have in the contract? Afiga, let's say you buy a house, Afiga. What kind of term and condition normally will you see in the housing agreement between you and the bank or between you and the government? Yeah, Afiga.
Maybe the years of you want to make a loan.
Correct. How many years do you want to repay the house? Let's say 25 years or 30 years. Yeah. Now, what happens if you fail to pay the loan, Dalia Jarai? What happens if I fail to pay my housing loan?
Consider breach of contract.
That means I don't fulfill my obligation in the contract.
Yeah.
So the bank have the right to what?
To tarik balik.
Tarik
Penalty.
balik. Yeah. Take back your house. Yeah.
Yeah.
Yeah. During the bad economy time, a lot of houses are taken back by the bank. Yeah. Now, talking about the consideration just now, yeah. When it comes to the key three elements that make up the contract, you remember, yeah, the three key elements that must be available in the contract. They must be offer. Somebody offer. The agent offer to me a car, Toyota Rush. That is the offer. Acceptance. I accept the offer to buy a Toyota Rush. Yeah, I accept. That is acceptance. Yeah. Now, the acceptance can be only become contract when I pay the car deposit, 20,000. Yeah. So that is the consideration. Yeah. I pay the deposit for 10,000, 20,000. Yeah. So that there is offer, acceptance, and consideration. Yeah. So in every contract, first, an offer must be made by one party to another party. There is one offer. Yeah. Next, the party receiving the offer must accept it. Yeah. What happens if the party don't accept it? Nicholas.
The contract cannot be do.
Yes, the contract is not valid. It cannot be enforced by law. Yeah, because the person refused to accept it. There is no consideration paid. Yeah. So there must be consideration in exchange. Yeah, between the two parties. Yeah, and this could be in monetary amount. Consideration can be monetary amount, for example, deposit, yeah, cash deposit, yeah. That is one example. Or another simple example, yeah, for consideration is a simple promise to act under the contract. There are two ways, yeah. Consideration can be carried out. One, yeah, there's a monetary amount involved, or a simple promise to act. Can you give one example? Siti Aisyah. An example of a simple promise to act. Siti?
Yeah, to give some discount.
Yes. When they promise to give 20% discount. Yeah, so that is a simple promise to act. Yeah, very good. Now, talking about capacity just now, yeah, capacity to sign an agreement. Now, when it comes to the legal capacity of a party, you must keep in mind those under the age of 18. Number one, under the age of 18. Two, those who are mentally incompetent. What is mentally incompetent, not competent, Sasha?
Sorry?
Let's say I cannot, I'm not mentally incompetent. That means I'm not competent mentally. Maybe sometimes they call it gila or mad, is it? Gila, you know, mad, yeah. Or I'm a minor. I'm under 18. Am I competent to sign a contract?
For the legal contractual think usually a person above the juvenile ages would be considered as a competent person to sign for the contractual.
Yeah, they must be 18 and above. Yeah, 18 and above years old. Yeah. How about when they are not able to think for themselves, can they sign a contract? Sasha.
For some contracts like Sharia contracts, which includes the family matters, they can sign for things like the hak penjagaan lah. But for any other professionals, I feel in my opinion, they should not be given the authority to sign any, since they are not legal, like for the pilihan raya before, just the age above 18 is considered the one that can be able to vote.
Yeah, like recently in Malaysia, the law has been passed. Yeah, all those above 18, yeah, they can legally vote. Yeah, so everybody above 18 years old, they can vote. Yeah, they are automatic voter. Yeah, and mentally incompetent does mean they cannot think for themselves. Yeah, these are the people who are OKU, for example. Yeah, who are handicapped, whether physically or mentally. Yeah, some of them are physically handicapped, some of them are mentally handicapped. So mentally handicapped, they are not competent to sign any agreement. Yeah, so the legal capacity required to enter into a contract, they must be of sound mind. Yeah, 18 years and above. Yeah, and they are able to think for themselves. Yeah, without any influence. Yeah, so these are what we call the legal capacity to sign a contract. Yeah, so while all contracts are unique, yeah, there are certain term and condition commonly used in contract, particularly business contract. Yeah, so these are generally referred to as the term and condition of the contract. Yeah, now the such term and condition will identify the rights and responsibilities. Yeah, Mr. Lee, what are your rights? What are your responsibilities of both party? Not only one party, both party. Yeah. So this can also include general and special condition. Yeah. Sometimes you can include general. Sometimes you can also include special condition. Yeah. So the general condition is one that is common. Yeah. General condition, one that are common. Yeah. And included in most contract. Special condition are those that are specific to the contract. For example, payment, price variation. Especially in engineering, you got price variation. Yeah. Penalties. Mr. Lee, Juntek, let's say you finish your study. Yeah. You finish your study. And you are supposed to pay the loan, the PT-PTN. Yeah. But because you did not get any job yet, yeah, so you cannot pay the PT-PTN loan yet because you have no job. Are you going to be charged penalty for that?
I think for that, at first we have to inform the PTPTN, telling them I'm not working, so maybe they will give an extension.
Yeah, so normally they
6
will
months to another
defer.
year.
Yeah, they defer the payment until such a time maybe you find a job, right?
Yes, correct.
Yeah, but in a hire purchase agreement, hire purchase contract, where you buy your car, or in her housing housing contract, yeah, house contract, yeah. Now, if you fail to pay the car or pay the house, what happened, Jessica?
You mean if we fail to pay?
Yeah, if we fail to pay.
Oh, and then someone will come and knock on your door and take away the property.
Yeah, that means we will be penalized. Yeah, there is penalty. First, the period you did not pay will be charged interest. Yeah, on the amount not paid. Yeah, interest on the amount not paid. Yeah. What happened finally you did not pay for 3 months or 4 months? What happened to your car? Bibi Amira.
They will issue a letter.
They will issue you a reminder.
A reminder letter.
Reminder letter, right? After reminder, under 4 months still not pay, what happened?
Maybe they will tow your car.
Then they will issue you the they will issue you the fourth schedule, they call it, yeah. In banking industry, they call it the fourth schedule. Normally issued on the 4 months, no payment. Yeah, on the 4th month, no payment. And with that schedule, they can tarik your car. They can take back your car, tow back your car, yeah. That is if we fail to fulfill the term and condition of the contract, yeah, we will be penalized, yeah. So be mindful that when someone refers to the term and condition, he is not referring to the overall contract, yeah. He is referring to certain legal terms within the contract, yeah, or some type of non-negotiable contract document, yeah. So when someone is referring to the actual contract, he isn't referring to such term and condition identified therein, yeah. He is referring to the overall contract or the legal relationship between the parties entering into the legally binding agreement. Yeah. What are the example of contract? Yeah, that you can find with term and condition. Yeah. For example, employment contract. Yeah. A sale of property contract, a warranty. Yeah. Or a consulting agreement. If you are an engineer, you have a consulting agreement. Or you have a lease contract or a joint venture. Yeah. So these are the example of the type of contract that we may have. Yeah. Now, normally, what are the term and condition in the contract? Yeah. While they aren't required legally mandatory, the term and condition are incredibly beneficial to both party. Yeah. So normally both party benefit from the term and condition. That means it protects the interest of both party. Now, what happens if there is some illegality or fraud in the contract? Can you enforce that contract? As Ninda.
Again, sir?
Let's say in the contract you do something illegal or you cheat somebody through the contract. Can you enforce that contract?
Okay.
Sorry?
Can, sir.
Why do you say can?
Meaning that I can enforce, meaning that I enforce the contract?
No, because you can't enforce. First, it is illegal. Illegal means it's against the law. Any contract that is against the law cannot be enforced. Yeah. Secondly, fraud. Fraud is cheating. Fraud is cheating. So anything to do with fraud or cheating, you cannot enforce the contract. Yeah. Now, what happen if the person is disqualified by law, to which they are subject to the law? Can that person sign a contract? Nur Hidayah.
No, doctor. Cannot, sir.
Sorry, tak boleh dengar, no?
Cannot.
Okay, about Siti Aisyah.
Yeah, doctor.
Let's say that person is disqualified by law to sign a contract. Can that contract be valid if it is signed by a person disqualified by law? For example, a bankrupt. Can a bankrupt sign any contract?
Not valid. The contract is not valid lah.
Right. The contract is not valid. You're right, Siti. Why is the contract not valid, Siti?
Because the person is not the one not qualified to sign. So to sign any agreement, there must be qualified person, which is he or she available to available to consider mematuhi that contract lah.
Very good. Yeah. That means by law, that person is already disqualified to sign the contract. Yeah. So if he is not qualified to sign the contract by law, that means whatever he signed is not a valid contract. The contract cannot be enforced by law. Yeah. So remember, yeah, who can enter into contract? Number one, the person must be age of majority, no more minor, according to the law. Yeah. A person of sound mind, because he knows the purpose of making the contract. Yeah. At the time he make the contract, he understand the contract. He is able to form a rational judgment that can affect his interest when he sign the contract, and he is not disqualified by law. Yeah. So a minor is not competent to contract. Anybody below 18. Yeah. So an agreement by a minor is void. Yeah. They call it in Latin ab initio. Ab initio. AB ab initio is INITIO. Yeah. Which sometimes we refer to an example of a fact, an act. Yeah. A document that was present from the beginning. That means from the beginning, he is already a minor, or she is a minor. So whatever contract that person signed is void. Yeah, cannot be enforced. Now, he cannot rectify an agreement on attaining the age of majority and validate the same. Yeah, that's what they call it. Void ab initio means it has no time. It has no legal validity. It means even though he signed the contract when the time he is still a minor, he cannot ratify the agreement. He cannot make good the agreement when he become the age of above 18, yeah, the contract cannot be validated. Yeah, remember that, yeah. So don't think that, oh, now my son is 19 years old or my daughter is 20 years old. He can ratify, or he can validate the agreement. No, they cannot do that. Yeah. So what makes a contract null? Yeah. That means contract will be voided if there is a mistake, if there is some mistake or fraud by any one of the party. A mistake or fraud by any one of the party, yeah. A contract may also be voided if a party entered into a contract under duress. Now, what do you understand by a party entered into a contract under duress? Adriana, Azman.
Yes, doctor.
Adriana,
sorry.
let's say somebody said, if you don't sign this contract, I kill you. Is this contract valid or void?
Void.
Void. Why void? Remember, at your master level, or doctorate or PhD level, you must not only say void, invalid, you must explain why. Very important, yeah. The basis.
Threatening the other person.
Correct, Brenda, because he is threaten the other party by hurting the other party, yeah. So he's under duress, dipaksa. Ling, I don't know what is it in Chinese, Ling, but in our local Malaysia language, we call it paksa. That means you are forced to do it. Yeah. Now, another type of contract that can be void is an unconscionable contract. Now, what does it mean? Unconscionable contract. That means you are not conscious. You don't know what is happening, but you sign the contract. Ika Natasha, can you give an example when you are in the situation of unconscionable? Ibrahim, can you help?
Yes.
Yeah. When you
I
are in the
get
situation of you are not conscious, but you are forced to sign the contract. Can you give one example?
usually like if someone is in um not drunk but or very serious sick or ill, usually this happen for the properties of like for the legacy of the family. They will use the contract for the to take over the legacy from them. So this will happen, but it's not legal.
Yes, very good typical example. Yeah, when the parents, the mother and the father, bedridden, very sick. Yeah, and then they force the father and mother to sign or maybe to thumbprint. Yeah, to thumbprint. Maybe at the time they are drunk. Yeah, they can be drunk, so they don't know what they're doing. Yeah, under that condition, they don't know that what they're doing. Yeah, so they are not conscious because of their sickness, because of the drunkenness. Yeah, and then you force them to sign the contract. That contract is called void. Yeah, it cannot be enforced. Okay. Now, what makes a contract not valid? Remember, yeah? What makes a contract not valid? Now, the object of the agreement is illegal or against public policy, unlawful consideration, or unlawful subject matter. Melisha, can you give an example of illegal or against public policy agreement? Nicholas, can you give an example? Sasha? Nor Hidayah? Siti Aisyah?
Maybe I can just try.
No problem, yeah.
When the employer forcing employee to sign a contract that forbid workers from joining any union.
That's mean in the banking industry, yeah. For example, we take a banking industry. If you are an officer in the banking industry, you are not allowed to join the union. Yeah. So if you join the banking union, you are an officer. That is illegal because that is not allowed by law. So that is an example of illegal. Yeah. Let's say what animal is protected in Sarawak? Thomas, can you give one example? An animal protected in Sarawak.
Orangutan.
Orangutan. Can you sell this orangutan?
No. Illegal.
No, because that is illegal. So that is an example of illegal activity. Now, can you give one example of an activity that is against public policy? Nicholas.
Doctor, system of law, regulatory measure, course of action, and funding priority concern against.
For example, the government policy, yeah, whereby everybody who is above 18 years old can vote. Yeah. What happens if you stop that person from voting, but he is already above 18 years old? Can or not you stop that person? No, Nickman. Cannot. Why cannot? Because it's against public policy. Yeah, it's against public policy, government policy. It's against the law. Yeah, very good. Now, the term of the agreement are impossible to fulfill or too vague to understand. So that makes a contract not valid. Can you give an example, Adriana?
Yes, doctor.
Sorry, you mean you didn't hear my question, is it?
Example of?
Yeah, an example. Let's say the term of the agreement, yeah, very difficult to fulfill, impossible to fulfill, yeah, or the term of the agreement is too vague, not difficult to understand. What are the term of the agreement? Yeah, can you give an example?
For example, if we want to buy a house as a normal person, like you cannot pay the full price of the house. It is impossible for someone that have an average wage.
Yeah, you're right. For example, let's say we buy a house. Let's say a middle income house. Yeah. So middle income, something like the income is 5 to 7,000 per month. Yeah. Yeah. If 5 to 7,000 per month, but the cost, the installment cost of the house is 2,000, 3,000. So that is impossible to fulfill because almost half of the half or more of the salary, right? Yeah, so that is impossible to fulfill. Now, an example of another void contract, yeah, there was a lack of consideration, no consideration, fraud, namely false representation of facts, yeah. So fraud has been committed, yeah. False representation, not telling the truth. That is the meaning. So that is also become a void contract. Now, under what circumstances can a contract be considered null and void? This is null and void, yeah. So a contract may be called null and void should the terms require one or both parties to participate in a illegal act. PB, can you give an example of an illegal act?
Human trafficking.
Yes, human trafficking. Yeah, that is an example of illegal act. Yeah, so definitely either I think both party will not be able to participate in the contract. Yeah, they cannot fulfill the term. Yeah, if one party becomes incapable of meeting the contract term, so that one also considered as null and void. Yeah, one of the party not able to fulfill the contract agreement. Yeah, now what makes a contract unenforceable? Yeah, is when one party doesn't understand the term or how they will be bound by it. Yeah. So if one party don't understand the term and the condition of the contract, yeah, and they don't know how are they bound by the term and condition, that is also means the contract is not enforceable. Yeah, it cannot be enforced. Now, lack of capacity, yeah, commonly applies to minors. It means any children under the age of 18, or they are mentally ill individuals. Yeah, minors, those below 18 and mentally ill, these are called lack of capacity. Yeah, the person cannot, they don't have the capacity to sign the contract. Yeah, or if the person under the influence of drug or under the influence of alcohol, these are also considered as contract cannot be enforced. Yeah. Now, how to make a contract legal? Yeah, very important. Yeah. So the basic elements we have mentioned just now. Yeah. There must be mutual assent. That means both parties agree. They must be expressed by a valid offer and acceptance. Yeah. There must be an offer, a valid offer, a valid acceptance. Yeah. And adequate consideration, capacity, and legality. Now, what do you understand by adequate consideration? Mr. Ling, can you try it in your opinion? What do you mean by adequate consideration? Mr. Ling? How about Lisa? Can you try, Lisa?
A consideration that is mutually agreed by two party.
Yeah, that is when the consideration is adequate. Yeah. What happened in this case? The consideration is inadequate. That mean, what do you mean by inadequate? That mean both party don't agree. Yeah. Let's say the agent of the Toyota car. Yeah. He said, you doctor, you must pay 10% deposit. Can I pay only 5% deposit, Lisa?
No.
No, that is considered as not enough consideration. Yeah.
Consideration.
Yes. Inadequate consideration. Very good, Lisa. Yeah. Now, in some area, yeah, in some state, the element of consideration can be satisfied by a valid substitute. What is the valid substitute just now? Can you give an example? Mahmudin, can try. What is a valid substitute?
Not sure, sir.
Oh, not sure. It's okay. Melissa. I hope I call your name correctly, Melissa.
Yes, doctor.
Yeah.
Sorry again.
We're talking about consideration, yeah. So one way of giving consideration is in terms of cash. Let's say 10% deposit, yeah, and that is cash deposit, yeah. Now, can we substitute cash deposit with other thing as consideration, element of consideration?
I'm not sure, doctor.
Yeah, we can. Yeah,
Okay.
like we mentioned just now, we can use a promise. Yeah, we can promise the salesman, yeah, who want to sell us the car, that I will pay the deposit, cash deposit, by end of this month. So that is a promise. There is no money given at that time, but I promise. Do you understand, Alicia? Melissa?
Yes, doctor.
Yeah, thank you. Okay. So how do you make a contract legal? Yeah, a legal contract is an enforceable set of promises made between two or more parties. Yeah, so both written and oral contract can be legally valid. Both written and oral contract, yeah, can be legally valid. Yeah, as long as all the elements required to form a valid contract are satisfied. There are three basic requirements just now. What is the requirement number one? Nicholas. Can you try? Number one, just now we talk about what? In order to have a valid contract, we have three basic requirements. What is one of the three requirements?
Acceptance.
Very good. Number two, no Hidayah. Acceptance.
Mutually agree.
Yeah.
Mutually agree.
Mutually
Mutually agree.
agree.
Yeah.
That means there is an acceptance. There is a proposal. Yeah. Yeah.
Yeah.
There is acceptance. There is acceptance. There is a proposal. Yeah. So these are the important condition. Yeah. for the party to fulfill to become a valid contract. Yeah. So as long as all the elements required, they form a valid contract. Yeah. Now there are two types of legal contract: bilateral contract and unilateral contract. Yeah. The majority of the contract are bilateral. It means in a bilateral contract, it means each party make a promise to other party. That is bilateral contract. Yeah, a contract to purchase good. These are the classic example of a bilateral contract. The seller agree to deliver the goods to the buyer, and the buyer agree to pay the buyer for the goods once they are received. Yeah, so this become valid bilateral contract. Now, in a unilateral contract, bilateral mean two party. Yeah, two party. Uni mean one party. Yeah. So in a unilateral contract, one party makes a promise to be carried out on a future that in exchange for a present action by the other party. Yeah. A good example of this type of contract is a liability insurance policy. Yeah. So you perform a present action by paying your monthly premium. Yeah. You pay your monthly premium for the life insurance. Yeah. In exchange for the insurance company promise to pay your claim in the future. Yeah, because the claim will be only paid when certain event happen to you. Yeah. So we don't know whether the event will happen or will not happen. Yeah. So that is the promise. Yeah. The payment in the future. So that become a unilateral contract. Yeah. So there must be for a valid contract. Yeah, there must be an offer, an acceptance, consideration. Yeah, and there must be elements of legality. Yeah, that means the purpose of the contract is legal. Yeah. Can you terminate a contract? Thomas Chawang.
Yes, I think if both party agree.
Yes, if both party agree. And most written contract, yeah, will include the term and condition that explain when the contract can be terminated. Yeah, contract generally terminate on a certain date. Yeah, for example, your car loan can be 5 years or 9 years or 10 years. Yeah, upon the performance of a duty of the contract or at the request of either party. Yeah, so many written contract will also include the term regarding how parties can terminate the contract. Yeah, if one party fail to perform the duty under the contract. So this failure to fulfill contract obligation is called the breach of contract. Yeah, that is if the contract if the party to the contract do not fulfill the condition. Yeah, so that is what we call a breach of contract. Yeah. Now, if the contract does not contain the term allowing for the termination of a contract, yeah, and if there is a breach, then the non-breaching party can pursue compensation from the breaching party through the court system. That means the non-breaching party, the party that did not follow the term and condition. Yeah, those party that those parties that are not against the term and condition, they can sue the other party who do not follow the term and condition, yeah, through the court system. Yeah. So in the court, there are several remedies for a breach of contract. Yeah. So most commonly, the non-breaching party can sue for damages. Yeah. Requesting the breaching party to make compensation. Yeah. In certain situation, the judge may order the breaching party to perform obligation required by the contract. That's what they call it, specific performance, or they can also terminate the contract. Now, okay, we talk about invalid contract just now already. Yeah. Now, very important. What is void contract in Malaysia? Listen properly. This is very important, especially for you, those in the engineering industry. Section 57(2) of the Contract Act 1950 said that a contract to do an act which after the contract is made become impossible or by any reason of some event which the promisor could not prevent, unlawful, becomes void when the acts become impossible or unlawful. That is a void contract, yeah? When after you sign the contract, yeah, but it becomes impossible for you to fulfill the condition of the contract due to some reason or some event. Yeah. The promisor could not prevent, or because it become unlawful. Yeah. Due to certain event, it become unlawful. So that contract become void. Yeah, because when the contract become impossible or unlawful, that is what we call void contract. Now, what are the grounds to avoid contract? How do you know that is a void contract? Yeah, a contract may be deemed void if the agreement is not enforceable as it was originally written. Yeah. So in such instances, void contract, sometimes void contract, we call it void agreement. Yeah. It involves an agreement that are either illegal in nature, not legal in nature, or in violation of fairness or public policy. That means the term and condition is not fair to either party, or it is against public policy. That contract becomes void contract. Yeah. Mr. No Nikman, can you give me an example of a void agreement? Adriana, can you assist? Adriana?
Yes, doctor. For example, if we hire an agent for to sell our house, and then we promise to give maybe 10% of the price of the house, and then when the house is sold, we didn't give the anything to the agent, then it's a void contract.
Very, very, very good, Adriana. Yeah, that is a very classic example. Yeah, I sell my house for 800,000, and I promise the agency, the housing agency, that I will give him or her 10%. But when I sold the house, I refuse to give the 10%, or I give less, maybe 5%. So that becomes not fair to the agent. And when it is not fair, it violates the fairness of the agreement, that become a void contract. Now, when is not legal in nature, Afika, can you give one example? Well, an agreement is illegal in nature.
Doctor, can I ask something?
Yeah, sure.
Regarding okay, what the differences of the breach of the contract? Let's say if you sell the house, you have the agreement to give 10% just now, but you on your party you you refuse to pay the 10%. So it's a breach of the agreement. Why
Right.
it become a void contract?
In the first place, for you to sign a valid contract, yeah, it means a valid agreement. The term and condition must be fair. That means both parties already agree. Yeah. If I tell you to sell my house, I give you 10%. That is the agreement between you and me. We agree that if you sell, I give you 10%. That is fair. Now, the moment you don't want to pay me the 10%, then you are not fair to me. When you are not fair to me, that agreement is void. That is the meaning. I hope you get the meaning, yeah, Mahmudin. So in every contract, it must be fair to both parties. That's why you cannot force people to sign a contract if they don't agree. If the term and condition is not fair, they don't agree, that is not a valid agreement. That is a void contract. Do you get me, Mahmudin?
So what can let's say the unfairness kan toward the agent just now, what the agent can do if the agreement is void? Can he summon you as because you breached the agreement?
So provided in the agreement, yeah, the moment you fail to fulfill the term and condition, that means in this agreement, one person breached the term and condition. So what did the term and condition say? If I breach the term and condition, then I can sue you in court of law. Then that provision will protect both parties. You know, if both parties did not fulfill the term and condition, one party can bring that person to court of law. So that's why the contract must be fair to all parties. Yeah, and the contract agreement to be valid must protect the interests of both parties. It cannot just take care of one party only. Yeah. Now, what is voidable contract? Just now we talk about void contract. Now we talk about voidable contract. Yeah. Now, a voidable contract is a valid contract. In this case, it's a valid contract. Voidable contract is a valid contract, which may be either affirmed. That means they ratify. Yeah, they make it valid. Affirm means they rectify, they make it valid. Or they can reject. Yeah. Remember, voidable contract is a valid contract. Yeah. They can either affirm or reject at the option of one of the party. Yeah. One of the party in the voidable contract, yeah, one either affirm or the other rejected. Nah, yeah. So at most, one party to the contract is bound. So under voidable contract, one party to the contract is bound. That means one party must be bound, must be responsible to the term and condition of the contract. Yeah. Now, the unbound party may repudiate the contract, at which time the contract becomes void. So, if the other party is not bound by the contract, but the other party is bound by it, the person who is unbound, the party who is unbound, they may terminate the contract. Yeah. At which time, during the time, the contract become void. Yeah. So, what are the difference between a void and voidable contract? So that is the question. Now, sometimes the term void and voidable contract are often confused. Yeah, very often confused. And sometimes use interchangeability. Sometimes people use it, oh, this time I use void, this time I use voidable. Yeah. Because you are confused. That's why you did not understand exactly the real meaning. Now, however, they are actually different meaning to the word void and voidable. Yeah. And without knowing the differences, it could lead to legal issues down the line. See? If you don't understand the real meaning of void and voidable, it will lead to legal issues, especially in the contract engineering environment. Yeah, whereby you have a lot of agreement. You sign a lot of agreement with another party. Yeah. Now, while void and voidable contract share some similarity, there are some similarity between void and voidable contract. But the differences are major and very important to understand. Yeah. The differences are major and very critical for all of you to understand. Okay? So, what does void mean? Yeah. A contract that are void means they cannot be enforced by either party. Remember, a contract that are void means they cannot be enforced by any party, A and B, no. Yeah. Now, if a contract that is no longer able to be used, yeah, a contract that is no longer able to be used, and the court will look at it like there was never a contract to begin with. Yeah. So that is the meaning of a void contract. In the first place, no party can enforce. If no party can enforce, then there is no longer, the contract can no longer be used. Because void, how can it be used? No party can use it. So the court, they will see void contract as, in the first place, from the beginning, there was never a contract. That is the meaning of void. Yeah. So one issue that can lead to a contract being void is the subject matter of the contract being illegal. You see, we relate void to illegality just now. Yeah. When the subject matter, the core business is illegal, there is no contract to begin with. When there is no contract, it's void. Yeah. So depending on the terms and what aspect was illegal, one or both parties could be facing criminal charges. Yeah. So depending on the term and condition and which aspect of that contract is void or illegal, so one party or both party could be facing criminal charges. So that is the meaning of void. Yeah, please remember that. Now, coming to the meaning of voidable. Now, I want BB, can you share with us first an example of a void contract? BB Amira.
Let me think first.
Can you repeat, please?
Let me think first.
Oh, okay. Brenda, yeah.
Contract, yes.
Yeah. Brenda. Let Brenda try first. Still thinking, yeah? Dahlia?
Void contract. I'm still thinking.
Oh, still thinking. How about Ika? Ika?
Prostitution. Where?
Still thinking, yeah? Ibrahim?
Voidable contract, I think.
Void contract is like
Somebody is
between
talking, yeah. Brenda, is it? What, Ibrahim? Sorry, Ibrahim. Brenda? Carry on, Brenda.
The contract which one party is under duress to sign.
Yeah, one party is under duress to sign. The other party put the pistol on his head. Look, if you don't sign, I shoot you. That is an example of void contract. Yeah, Ibrahim. Yeah, good, Ibrahim. Can you give another example?
The term of contract are illegal.
Who's talking? I don't know who's talking here. Sorry. Ika, are you talking, Ika?
No.
Sorry.
In Dahlia.
Oh, Dahlia. Okay, yeah. Carry on, Dahlia. Sorry. Yeah, carry on.
The term of the contract are illegal.
The term of the contract are not legal. Yeah.
Yeah, illegal. Yeah.
Yeah, it is an illegal contract. For example, selling heroin.
Selling human. Prostitution.
That is illegal. Yeah, Nur Nikman. Please say with us.
Doctor.
An example.
The example of void contract is inside the contract there is one clause. It is called exit clause. Inside the exit clause, both party agreed the terms of exit or the terms of if the contract is void. So if any things that happen to the contract, it falls under exit clause. Is the contract is automatically void. The example of void contract is the MOU. Once memorandum of understanding is being signed and the agreement has been signed, the MOU will be automatically void. This is the example of contract void.
Thank you very much. Yeah, these are the actual example of a void contract. That means all of you understand what is a void contract. Nah? Very good. Now, go to the, what do you mean by voidable contract? Yeah. So when with a voidable contract, one party can be bound by the contract term, while the other party has the right to change their mind. Yeah. One party under voidable contract can be bound by the contract term. Yeah. But the other party has the right to change their mind. Still got the right to change their mind. In other words, they can cancel the contract whenever they want. So that is one situation, you know. One party bound, the other party still have the right to change their mind. Yeah. So they can cancel the contract whenever they want. Yeah. Another situation that could render a contract voidable is mutual mistake, or when important material is missing from the contract. Yeah. An example of a voidable contract is one involving a minor. Yeah. Minor can enter into a contract, but they can also decide to breach the terms without legal repercussion. You see? Yeah. Because the minor, he or she is involved in a voidable contract. Yeah. That is what they call it voidable contract when it involve a minor. Now, the minor can enter into a contract, but subsequently they breach the condition. Yeah, be careful. You sign a contract with a minor and they breach the condition. Yeah. In the end, there is no legal repercussion to the minor. Yeah. This is what the law say. Yeah. So there are other party who cannot enter into a legally binding contract either. Yeah. There are other party who cannot enter into a legally binding contract. Yeah. Including someone who lacks the mental capacity. Remember it now? Yeah. Or somebody intoxicated, drunk, or somebody on drug at the time the contract was drafted. Yeah. These people, they lack the capacity, mental capacity, because of their condition. They're either on drug or they are drunk. Yeah. So this party cannot enter into a legally binding contract. Yeah. So at the time the contract was drafted, it is called a voidable contract. Yeah. So what are the main differences between void and voidable contract? Yeah. With a void contract, it is invalid from the very beginning. From the very beginning, the void contract is not valid. Yeah. It doesn't require one party to back out or challenge the validity. In this case, neither party can enforce a void contract. Yeah, because it is viewed from the fact that the contract never exists in the first place. Yeah. For void contract, the contract never exists in the first place. Yeah. Now, for a voidable contract, it doesn't become invalid until one party exert a legal reason for cancelling or revoking it. Yeah. Voidable contract, it doesn't become invalid until one party they take legal reason to cancel or to revoke the contract. Yeah. This means without one party raising a legal objection, the contract would remain valid under voidable contract, if nobody take action, if no one party take any legal action, legal objection, the contract remain valid. Yeah. So contract that are no longer enforceable become void. Remember, contract that are no longer enforceable become void. If one party uses a tactic like fraud or coercion, doesn't mean you force that person, the contract will become voidable as well. Yeah. So with a void contract, the contract can become valid just by both parties agree, or as you can commit to doing something illegal, because you can't do anything illegal. Yeah. So that is a void contract. Yeah. Even if both parties agree, even if both parties disagree, because whatever they do, they commit something illegal. Yeah. But for voidable contract, it can be made valid if the party who isn't bound agree to give up their right to the rescission. Yeah. So an example of a void contract could include prostitution, gambling. Yeah. That an example of a void contract. If you force somebody to become prostitute, if you force somebody to gamble, yeah, that is a void contract. Yeah. If someone enter into a contract and is suffering from a serious illness or was mentally incompetent, it would be void. Yeah, because the party lack the legal capacity to enter into a contract. Yeah. So when consent to an agreement is caused by coercion, fraud, misrepresentation, that the agreement is a contract avoidable. A contract voidable at the option of the party whose consent was so caused under section 19(1). Yeah. So there must be some coercion, fraud, misrepresentation. Yeah. So in a void contract, yeah, it is not valid or legally binding. That is the meaning of void contract. It is not valid or not legally binding. So this is under section 57(2) of the Contract Act 1950, which clearly spell out that a contract to do an act which after the contract is made become impossible, or by reason of to some extent the permission could not prevent unlawful become void when the acts become impossible or become unlawful. Yeah. So I hope you all understand the difference between void and voidable contract. Yeah. Okay. Now, what do you need to do to avoid contract? Yeah. What if I need to void a contract? Yeah. So generally speaking, yeah, when a contract is void or voidable, the process is the same. It is necessary to file a request with the court in order to have the contract reviewed. Yeah. This will help the court to determine whether the contract is void or simply voidable, and what other remedies could be available. Yeah. An example of this would be how a damages award may be made available for the extra losses that were caused because of the breach of contract. But maybe this can be only on specific example, yeah, circumstances, yeah. So if you find yourself needing to have a contract voided, yeah, you should refer to your copy of the contract, yeah, refer to the copy of contract as well as any other important documents from the contract formation process, yeah. Or additionally, you should keep records of the receipt, the bill, and other document, yeah, to prove that any losses that you have incurred as a direct result of being involved in the contract. Yeah. So these are the important things that you must take note. Yeah. So to simplify the process of having a contract voided generally follows this step. Yeah. Number one, the contract is reviewed for terms or factors that may cause it to be invalid. Determine the legal reason as to why the contract should be void, such as under duress during the time of signing. The collection of document and information supporting that reason. You must collect document and information to support that reason. Yeah. Determine whether an entirely new contract is needed. From there, you decide whether you need a new contract. Yeah. Or portion of the contract to be rewritten. Or alternatively, the contract can be abandoned altogether. Yeah. So I think that is all for today. Do you have any question or not on today class? Yeah, Mr. Lee said no question. Yeah. Nicola said no. Brenda said no. Thomas, Adriana, no.
Sir,
Yeah.
sir,
Yeah.
I'm
Yes.
Asminda S.
Yeah.
I am Asminda S.
Yeah. Yeah.
Okay, just one question. If the rep the signing the agreement is dead, is it the contract become void?
If the date of signing the agreement is
No,
what?
no, no. If the signage the rep of the company, maybe one rep who is signing the binding agreement is dead, is it the contract is still valid or not? Or maybe it's just a representative of company can replace him, or is it still have a new agreement or new signature?
Oh, if somebody else signs the agreement.
No, that meaning that first he signed the agreement, and then after that,
Oh, first he signed the agreement and then after that he passed away, is it?
Yes, pass away. Yes.
The other party passed away.
Yes.
Now, normally when one party, that's mean the contract no longer valid because one party cannot fulfill. Under that circumstances, that condition, one party cannot fulfill the agreement, definitely. So the agreement automatically terminated. Unless in the agreement you state once any party pass away, the daughter or the son or the wife or the husband automatically become party to the contract. Yeah, unless the term and condition put it in that way. If it is silent, it is deemed to be terminated. The contract is deemed to be terminated. All right?
Doctor?
Yes?
how about let's say the reps of the company, the CEO signed the agreement, and the CEO being sacked from the company.
That is very interesting. Yeah. In this situation, the CEO is being sacked by the company. Yeah. So, normally the CEO or the officer signing on behalf of the government or on behalf of the company, they will use not their own personal name. They may have the name there, but they have the post, like you said just now, the post of the CEO. Or if let's say in the government department, the head of the government department or the senior officer in charge of the particular division. Yeah. Jawatan, atas jawatan. That means on the position. The position is forever with the company. It is forever with the company, forever with the department. If that person is sacked, yeah, no more CEO, but the CEO post is still there. The contract is still valid.
Although when they change the new CEO, they're totally a different person. So it's totally with the new direction and new everything. I mean, it's not his signature, but he's still a blind. Is it the company? The company is still a blind with the agreement that the previous CEO signed?
Yes, as long as the signing is under the name of the CEO, not under the name of Mahmudin Sabli personally. No, it is signed. Up there is your name, Mahmudin Sabli, but the post is there, Chief Executive Officer, which is forever with the company. So it's still a valid contract. That's why when the government department sign any agreement, they use the official title of that post, that jawatan. Yeah. Setia Usaha Bahagian, like that. Yeah. Mahmudin Sabli, Setia Usaha Bahagian Contract. Secretary to the contract section. So the officer in charge of the contract section is always there. He will be, the post is always there. So he is signing on behalf of the organization of the department. Yeah, he is not signing on his own capacity, personal capacity, but capacity as the jawatan, as the post carry.
If the post remain vacant after a while?
No, whether vacant or the post is somebody sit down on it, it is not material. As long as the signing is on behalf of the organization or on behalf of the department, the contract is valid. The term and condition is valid. Unless you said in the term and condition that upon Encik Mahmudin Sapli, the CEO, resign, this contract is void. Then it's void. If it is silent, it is deemed as still valid. That is the contract of the law. Yeah. Last time we have one case between the government of Malaysia. Yeah, one case I audit, whereby this company they use that logic of the officer resign, the contract officer resign, but the court said no. The post of the person who signed is always there. The personal person no more there, but the post is still there. the prime minister post, for example, he's still the prime minister, even though the previous prime minister is signing the agreement. But the new prime minister is the current Datuk Anwar Ibrahim. But the previous contract signed by the previous prime minister is still valid. Yeah. Any other question? If no more question, thank you very much to all of you. I really enjoyed the discussion. Yeah. Even though some of you take time to think, that is normal. Yeah. We always take time to think. Yeah. Yeah, Dahlia. I invite Sasa. If Sasa, I would like to see your research topic. Yeah. Your objective and your problem statement. Yeah. I would like to see you. Brenda, I think I already give you the objective. I already corrected your objective. Maybe after finishing your class, maybe tomorrow we can discuss again on your problem statement. Yeah, Brenda.
Okay.
Sasa, are you available after this? Sasa?
Yeah.
Yeah. So we can continue the discussion using this using this link. Yeah. The rest of the student, please you can leave. Sasa, you call me after this. Yeah.
Thank you, Doctor.
Yeah, sure.
Thank you, everybody.
Thank you, Doctor.
Everybody.
Thank you, Doctor.
Thank you, Doctor.
Thank you. Hello, Sasa.
Yeah.
Okay, can you share your topic and your write up?
Try to find first.
Okay, sure.
You want me to share this by WhatsApp or email to you?
You share in the what in the screen now?
Oh, okay.
Yeah, stay in the screen now.
I'm sorry, doctor. It says that I am not allowed to share.
Oh, I see. If you can open a different link because I don't have your soft copy. I don't have anything from you yet with me lah. Unless if you maybe you email to me, ambrosedango@gmail.com. Do you got my email?
Yeah. Ambrose
You
email.
yeah. You email to me, then I have a look at it, and then I will give you my comment.
Okay, sure.
Yeah, thank you.
Okay.
So I just left this meeting. Yeah.
Okay, sure.
Let me give me time to read it. Yeah.
Okay. Thank you, doctor.
Thank you. Yeah, thank you.